it means that those outside the court have already come to the conclusion that the court's job is to produce the outcome that they want, rather than to decide whether or not the process by which the decision was arrived at is a constitutional one.
Welcome to The Debrief, where we talk with the Washington Examiner's top journalists about the headlines they're covering this week and where the story's going next. I'm Sarah Westwood, and I'm here today with Editor-in-Chief Hugo Gurdon. And Hugo, you wrote in a column this week about the Supreme Court case involving Biden's student loan forgiveness plan. You wrote about first how weak the legal defense of that program is from the Biden administration, and also, some observations about what protesters outside the court must think about the role of government. So let's just start with that first point that you made. Why is the Biden administration's defense of this so weak?
Well, Sarah, it's weak because it's somewhere between $500 billion of forgiveness and $1 trillion of forgiveness. This is an enormous amount of money that President Biden is doing by executive order. The reason he's doing it by executive order is that it wasn't something that Congress passed, and it is generally understood as our constitutional. The Constitution requires that sums of that sort are approved by Congress. He's doing it under the authority of the HEROES Act of 2003, which was a piece of legislation passed by Congress at the beginning of the Iraq War, which was designed to ensure that men and women fighting for their country abroad would not have the extra burden of repayment worries hanging over them. The act does, however, include the word just emergencies, and what Biden is doing is talking about the COVID emergency giving him authority to do this. But he has already said himself that the emergency is over, and it's formally going to be over in May. So I think that it is a very weak case on the merits. There is one problem for those who oppose it, and which might help Biden, and that is whether the court decides that those who are suing have standing, because they have to show that they would be harmed by, specifically they would be harmed. It's not just that it's a bad executive order and Biden shouldn't be doing it, but the plaintiffs need to be harmed. So that might be where, if Biden can get this through, if it can get through the court, it'll be because of standing, probably.
That was already a problem in some of the lower courts where this was heard. You also talked about what the protesters that we saw outside the Supreme Court this week must think about the role of government if they're demanding a specific outcome from the Supreme Court. Tell us about that.
Well, one of the things that always strikes me when you see protesters out there they make the case, not just as they did on their placards, that student loan repayment is legal, but they sort of more emotive things like 40 million families need student loan forgiveness. The problem with that is that that's entirely a political matter which the Supreme Court is not supposed to be adjudicating. The court is simply there to decide whether or not the government is acting within, the administration in this case, is acting within the parameters of the Constitution and of statute. It means that those outside the court have already come to the conclusion that the court's job is to produce the outcome that they want, rather than to decide whether or not the process by which the decision was arrived at is a constitutional one. And of course, if it's not constitutional, it isn't democratic.
And finally, politically, if the Supreme Court strikes this down, where does this leave Biden? Does he go to Congress, get them to sort of codify this into law? Does he have that kind of goodwill with lawmakers?
No, absolutely not. I mean, there's no way now that this would get through the House, and I think it's pretty doubtful that it would get through the Senate either. I think that he's already at the last resort with student loan forgiveness, because it was discussed as a possibility, and he wanted it in the CARES Act, which gave relief to small businesses, for example, but it was discussed, and specifically Congress decided not to include it in the CARES Act. So even under the last Congress, he couldn't get it through. So the chances of him getting it through when there's a Republican majority in the House are exceedingly slim. And that's why he's now in the Supreme Court.
Well, Hugo, thank you so much for being here today. You can get more writing from Hugo and the rest of the commentary team at washingtonexaminer.com.